Hello, everyone. So, I hope you all are studying well and you are amazing. Your studies are going amazing and you are feeling all the motivation that you need to study. Sometimes it's okay to feel not okay to study, but still, I hope still the studies are going on at a good pace. Today, I'm going to discuss with you the RTP that the Institute has issued for the September foundation exams, and let's just go into it. So the first question is from the first chapter, Indian Regulatory Framework. What is law and what is the process of making law? So can I say law is nothing but a set of rules and principles which are formed to govern the society? Yes. What is the process of making the law? First of all, a bill is made, which is laid down in both the houses of the parliament. First, Lok Sabha, it is passed there, then Rajya Sabha, it is passed there. Once it is passed in the Rajya Sabha, the president signs it, it gets the assent of the president, and then it is notified in the official gazette. Once it is notified in the official gazette, it becomes an act. So moving on to the next one. The next is from the Indian Contract Act, the next few set of questions. Explain the type of contracts in the following agreements. Rahul contracts with Bhanu for the supply of 10 tons of sugar, but before the supply is affected, the factory catches fire. Can we say supervening impossibility and everything is destroyed? Yes, this is what supervening impossibility. And what happens to the contract? The contract is void. A coolie in uniform picks up the luggage of Rohan to be carried out of the railway station without being asked by Rohan, and Rohan allows him to do so. So, without being asked by Rohan, and he allows him to do so. So first rule says consideration must move at the desire of the promiser. But when you see the other person doing the work and you don't stop him, he's not doing it free of cost. So are you liable to pay him? Yes. Quasi contract, obligations created without law. Which heading? Work done non-gratuitously. Obligations of finder of the goods to return them to the true owner. So whenever there is a contract between the owner, so whenever a person finds goods belonging to another, there is a quasi contract between the finder and the owner that the finder will trace the owner and return the goods back to him. So what type of contract it is? It is a quasi contract. Amit, a minor, was studying in a college. On 1st July 23, he took a loan of 1 lakh from Bhavesh for payment of his college fees and to purchase books and agreed to repay by 31st December 23. Amit purchased Amit possesses assets worth 9 lakh. First of all, he took a loan of 1 lakh for his college fees and purchasing books. That means, can we say the loan was taken for necessaries? Yes. Amit has assets worth 9 lakh. On the due date, Amit fails to pay back the loan to Bhavesh. Bhavesh now wants to recover the loan from Amit out of his assets. In case of necessaries supplied to a minor, the minor is never personally liable, but the assets of the minor is liable, right? So here, whether Bhavesh would succeed? Yes. Can I say he can recover the money from the assets of the minor? Yes. Mr. Sham, aged 58 years, was employed in a government department. He was going to retire after 2 years. Mr. Dev made a proposal to Mr. Sham to apply for voluntary retirement from his post so that Mr. Dev can be appointed in his place. Mr. Dev offered a sum of 10 lakh as consideration to Mr. Sham to induce him to retire so that he can get his place. Don't you think he is bribing him for what? For a public post. Correct or not? Right? Because he is working in a government office, right? He is working in the government department. Now, Mr. Sham refused at the first instance, but when he evaluated the amount offered is just double of his cumulative remuneration to be received during the tenure of 2 years. He agreed to receive the consideration and accepted the above agreement to receive money to retire from his office. Is the agreement valid? No, the agreement is void. Why? Because it is sale of public offices. It is what? Sale of public offices. So moving on to the next one, what will be the rights of the promiser in the following cases under the Indian Contract Act? Explain with reasons. Sunil promised to bring back Jatin to life again. Now this is something which is impossible to perform. It is void ab initio, correct or not? So no rights at all. Aman agreed to sell 50 kgs of apples to Raman. The loaded truck left for delivery on 15th March, but due to riots in between, reached Raman on 19th March, due to which the apples were rotten. Now, here, can I say time is of essence? Because the goods are perishable goods, time is of essence. And since the goods could not be reached before the time, the contract becomes what? Voidable, right? And obviously, in this case, it will become void. An artist promised to paint on the fixed date for a fixed amount of remuneration, but met with an accident and lost his both hands. Can we say this contract becomes void? It's not void ab initio, but it becomes void at a later stage due to impossibility of performance. The contract is what? Void. So no rights. Abhishek entered into a contract of import of toys from China, but due to disturbance in the relation of both the countries, the imports were banned. Because of outbreak of war, supervening impossibility, the contract now becomes void. So the parties will have no remedies at all. Seema was running a boutique in New Delhi. She had to deliver some cloth to her friend Kiran, who was putting up an exhibition in Mumbai. Seema delivered the sewing machine and some cloths to a railway company to be delivered at a place where the exhibition was to be held. Seema expected to earn an exceptional profit from the sales made at this exhibition. However, she did not bring this fact to the notice of the railway authorities. The goods were delivered to the place after the conclusion of the exhibition. On account of such breach of contract by railway authorities, can Seema recover the loss of profit? No. Special damages can be claimed only when there is a notice of the special loss. Here, she did not mention this to the railway authorities. Can she claim these damages? No. Explain the 5 cases where the contract is discharged with the consent of both the parties. Novation, rescission, wow, remission, alteration, and waiver. Right? Suraj guarantees Vikas for the transactions to be done between Vikas and Nikhil during the month of March. So that means, can I say this is a continuing guarantee? Yes. Vikas supplied goods of 30,000 on 1/3/23 and of 20,000 on 3/3/23 to Nikhil. On 5/3/23, Suraj died in a road accident. So Suraj had given a guarantee, and this person is dead, and it was a continuing guarantee. Can I say on the death of the person, the guarantee is revoked? But is it completely revoked, or is it revoked for the future transactions, for the future? So guarantee is revoked with respect to future transactions. Correct? Now, on 10/3/23, being ignorant of the death of Suraj, Vikas further supplied goods of 40,000. Doesn't matter. The moment he is dead, it's an automatic revocation. On default in payment by Nikhil on the due date, Vikas sued the legal heirs of Suraj for recovery of 90,000. For the contracts made before Suraj ka death, which is how much? 50,000. Will the property of Suraj be liable for that? Yes. But for the contract made after his death, will the property be liable? No. Are liable to pay 90,000 under the provisions of Indian contract. So, sorry. Describe whether legal heirs of Suraj are liable to pay 90,000 under the provisions of the Indian Contract Act. No. How much are they liable to pay? 50,000. But tell me, are the legal heirs personally liable, or they are only liable up to the property? Only up to the property. Here, let's say, what would be your answer if the estate of Suraj is worth 45,000? Then in that case, they will only be liable for 45,000 and not 50,000. Mr. Stephen owns a chicken farm near Gurugram, where he breeds them and sells eggs and live chicken to retail shops in Gurugram. Mr. Fleming also owns a similar farm near Gurugram. Doing the same business, Mr. Fleming had to go back to his native place in Australia for 1 year. He needed money for travel. So he had pledged his farm to Mr. Stephen for 1 year and received a deposit of 25 lakh and went away. At that point of time, the stock of live birds were 1 lakh and eggs were 10,000. The condition was that when Fleming returns, he will repay the deposit and take possession of his farm. After 1 year, Fleming came back and returned the deposit. At that time, there were 1,09,000 live birds and 15,000 eggs. Mr. Stephen agreed to return 1 lakh birds and 10,000 eggs only, state the duties of Mr. Stephen as pawnee, and advise Mr. Fleming about his rights in the above case. First of all, can Mr. Fleming, as the pawner, has a right to claim back his goods? Yes, claim back his goods. Now, as Mr. Stephen was the pawnee, it is his duty to return the goods back on the receipt of money. Further, as per the contract of bailment, any accretion to the goods must also be what? Returned back. So that means, can we say that Mr. Fleming has a right to recover 1,09,000 live birds and 15,000 eggs, and it is Mr. Stephen's duty to return them. Right? Now moving on to Sale of Goods Act. AB Cloth House, a firm dealing with the wholesale and retail buying and selling of various kinds of cloths customized as per the requirement of the customers. They dealt with silk, organdy, cotton, khadi, chiffon, and many other different varieties of cloth. Mrs. Rima, a customer, came to the shop and asked for a specific type of cloth suitable for making a suit for her daughter's birthday. She specifically mentioned that she required cotton silk cloth which is best suited for the purpose. The shop owner agreed and arranged the cloth pieces cut into as per the buyer's requirement. When Rima went to the tailor, she found that the seller has supplied her cotton organdy material cloth not suitable for the said purpose. It was heavily starched and not suitable for making the suit that Rima desired for. The tailor asked Rima to return the cloth. The shop owner refused to return the cloth on the plea that it was cut to specific requirements of Mrs. Rima and hence could not be resold. With reference to the doctrine of caveat emptor, explain the duty of the buyer as well as the seller. Tell me, also explain whether Mrs. Rima would be able to get the money back or the right kind of cloth as per the requirement. Can I say, as per caveat emptor, Mrs. Rima, the rule of caveat emptor will not apply here. Caveat emptor says, let the buyer beware. But when the buyer has specified the reason of his purchase to the seller and depends upon the seller's skill and judgment, and the seller deals in those goods, it is the seller's duty to supply the goods that suit the buyer's purpose. It is not the buyer's duty. And if the goods do not suit the buyer's purpose, can the buyer return the goods back? Yes. Now the question is, can she get back her money or she will get the right kind of cloth? Since it was the fault of the seller, she has a right to decide whether she wants her money back or the cloth. She has a right of choice, and if she wants her money back, she'll get her money back. If she wants the cloth, she'll get the cloth. Samuel purchased a television set from Arun, the owner of Gada Electronics, on the condition that for the first 3 days he will check its quality, and if satisfied, he will pay for that. Otherwise, he will return the television set. On the second day, the television set was spoiled due to an earthquake. Arun demands the price of the television set from Samuel, whether Samuel is liable to pay the price under the sale. First of all, the goods were given for 3 days. Then on the second day, the television was spoiled due to an earthquake. That means not anyone's fault. By then, Samuel had not accepted the goods. So who is the owner? Arun. Arun demands the price. Can he demand it? No, because sale had never taken place. Suraj sold his car to Sohan for 1,75,000. After inspection and satisfaction, Sohan paid 75,000 and took possession of the car and promised to pay the remaining amount within a month. Later on, Sohan refuses to give the remaining amount on the grounds that the car was not in a good condition. Advise Suraj as to what remedy is available. So he took, and later he refuses to give the remaining amount. That means now Suraj has become what? Unpaid seller. An unpaid seller has both rights against the goods and against the buyer. But for the goods, rights against the goods must be with him. The goods have already been delivered to Sohan. So can he have rights against the goods? No, he will have rights against the buyer. What are the rights against the buyer? To sue for price, to sue for interest. Akash purchased 100 kgs of wheat from Bhaskar at rupees 80 per kg. Bhaskar says that wheat is in his warehouse in the custody of Kishore, the warehouse keeper. Kishore confirmed to Akash that he can take the delivery of wheat from him. Until then, he is holding the wheat on Akash's behalf. Can I say this is the delivery has already been made to Akash? Yes. This is what constructive delivery. Before Akash picks the goods from the warehouse, the whole wheat in the warehouse has flowed in flood. Now Akash wants to, sorry, wants his price on the contention that no delivery has been done. Whether Akash is right? No. The delivery has already taken place and he cannot claim the money. Cannot claim the price because the delivery has already taken place. The next one, Indian Partnership Act. Sahil, Amit, and Kunal were partners in a firm. The firm is a dealer in office furniture. They have regular dealings with Messrs. AB and Company for the supply of furniture. On 30th June, one of the partners died in a road accident. The firm ordered Messrs. AB and Company to supply the furniture for their business on 25th May, when Kunal was also alive. Now, Kunal was alive. The order was placed. Now, Sahil and Amit continue the business in the firm's name. The firm did not give any notice about Kunal's death. We don't have to give any notice in case of death. The persons dealing with the firm. Messrs. AB and Company delivered the furniture to the firm on 25th July. The fact about Kunal's death was known to them at the time of delivery. The order was placed on 25th May. On 30th June, Kunal died. On 25th July, the goods were supplied. Here, I have just placed an order. The order was never accepted. The goods were never delivered. The liability has not arisen. The liability arises on 25th July. On 25th July, was Kunal even alive? No. So, is Kunal liable for this supply? No. Afterwards, the firm became insolvent and failed to pay the price of the furniture. Now, Messrs. AB and Company had filed a case against the firm for the recovery of the price. With reference to the Act, explain whether Kunal's private asset will be liable. No. The deceased partner's liability is only up to the date of his death. Here, the goods were never delivered, the liability was never there. So, Kunal's assets are not liable for this furniture. State whether the following are partnership under the Indian Partnership Act 1932. A and B buy commodity X and agree to sell the commodity with sharing the profits equally. Yes, it's partners, particular partnership. Two firms, each having 12 partners, combined by an agreement into one firm. Yes, two firms can form a single partnership. A, B co-owners agree to conduct the business in common for profit. See, just because they've used the word co-owners doesn't mean they are not owners. They are not partners. They are doing business, they are going to share profits, and obviously for their common profit, mutual agency is there. So are they partners? Yes. Some individuals form an association to which each individual contributes 5,000 annually. The objective of the association is to produce clothes and distribute them free. So there is no profit motive here. And the motive of partnership is always profit. So this is not partnership. A and B co-owners share between themselves the rent. I've already told you, rent is never considered as business. So lending your property is never considered as partnership. When does dissolution of partnership take place under the provisions of dissolution of partnership can take place in 6 different ways: retirement, death, admission, expulsion, insolvency, and transfer of shares. State the rules regarding registered office of the LLP. Every LLP must have a registered office. All the documents of the registered. Oh, I'm so sorry. For the previous question, it's dissolution of firm. I'm sorry. I read it wrong. Partnership firm. Partnership firm can be dissolved without the order of the court, or it can be dissolved with the order of the court. Without the order of the court, it may be by agreement where all the partners mutually decide to dissolve the firm. It can be on the happening of certain contingencies. For example, firm was formed for a purpose, purpose is over. Firm was formed for a time, time is over. A partner is dead, a partner is insolvent, except when all are dead, except when all are insolvent. By notice, it is a partnership at will, and any partner can give a notice and dissolve the firm or retire from the firm. So, in that case, we can dissolve the firm. When a partner or any third party applies to the court may declare for the dissolution in any of the cases. Permanent incapacity of an active partner, misconduct of a partner, perpetual losses, consistent breach, partnership becoming an illegal association, business becoming illegal, except when all are dead, all are insolvent, deadlock in the management, or any just and equitable grounds. State the rules regarding registered. Every LLP must have a registered office. All the documents to the LLP or to the partners will be sent to the registered office. Can the LLP change its registered office? Yes. Any change should be notified to the registrar. Now, Companies Act. AB&C has decided to set up a new club with the name of ABC Club, having objects to promote welfare of the Christian society. They plan to do charitable work or social activity for promoting the artwork of economically weaker section of the Christian society. The company obtained the status of Section 8 company and started operating from 1st April 21 onwards. However, on 30th September 23, it was observed that the club was violating the objects of its objective clause, due to which it was granted the status of it was violating the objects. What are the powers of central government? First of all, central government can revoke the license. And when the license is revoked, three things can happen. Either convert into a private or a public company, or amalgamate with another Section 8 company, or winding up of company. Right? The next one, HP Politic Limited has a paid up share capital divided into 6 lakh equity shares of 100 each. 2 lakh shares are held by the central government and 1,20,000 is held by the government of Maharashtra. So out of 6 lakhs, so what is 51% of 6 lakhs? Sorry, I'm still a little traditional method I'm using. 3 lakh 6,000. How much is the government holding altogether? 3 lakh 20,000. Is it a government company? Yes. No limit private companies incorporated as an unlimited company having share capital of 10 lakh. One of its creditors, Samuel, filed a suit against the shareholder, Mr. Innocent, for recovery of his debt against no limit private company. It's an unlimited company. Mr. Innocent has given his plea in the court that he is not liable as he is just a shareholder. Explain whether Mr. Samuel will be successful. No. When we say unlimited liability, the liability of the member is unlimited towards the company, not towards the creditor. The creditor can recover from the company, who in turn can recover it from the member, but the member is never personally liable to the creditor. So Samuel will not be successful. What are negotiable instruments? Explain. Negotiable instrument means any promissory note, bill of exchange, or check payable to or to the order of or to the bearer of the instrument. Characteristics: it's freely transferable. The holder gets the instrument free from all defects. It must be in writing. It must be signed. There must be a promise to pay. It must be a promise to pay money only. There should be some consideration. It should be stamped. Actually, theoretical questions, I don't want to go too much of details. Manoj purchased some goods from Sagar. He issued a check to Sagar for the sale price on 14 June. Sagar presented the check in the bank and his bank informed him on 19 June that the check was returned unpaid due to insufficiency of funds in the account of Manoj. Sagar sued against Manoj under Section 138. Whether this suit is maintainable. Well, in case under Section 138, if a check is dishonored due to insufficiency of funds, the punishment is twice the amount of the check, or up to 2 years of imprisonment, or both. But for this to happen, there are a few conditions that must be fulfilled. First, it must be for a lawful debt. It must be presented within the time period. And once the banker gives you a notice, within 30 days, you must give a notice to the drawer that the check has been dishonored. Within 15 days, if he does not pay, then you can sue him. So first, is it for a lawful debt? Yes. Is it presented within time? Yes. So if he gives a notice, okay, if Sagar gives a notice to Manoj and within 15 days Manoj does not pay, then Sagar can go and sue him. So I hope this was clear to all of you, and I hope you're practicing writing your answers. If this video helps you, just leave a like and a comment so that we are also motivated. Happy learning and stay motivated.